Judgment in the matter of Nasir against Zavarco.
The appellant, Tan Sri Nasir, is a Malaysian citizen who was a shareholder in the Respondent company Zavarco plc. The appellant subscribed for shares in Zavarco. Those shares had a nominal value of 36 million euros. At the same time, he transferred to Zavarco the shares of another company, which then became Zavarco's subsidiary. Later, the appellant was involved in a dispute with Zavarco when Zavarco demanded that he pay the 36 million euros for the shares which had been issued to him. His case was that his transfer of the shares in the other company to Zavarco had been consideration for the issue of the shares in Zavarco. In the court action which followed, Zavarco sought and the judge granted declarations to the effect that the shares in Zavarco, which the appellant held, were unpaid, and that Zavarco was entitled, under its Articles of Association, to forfeit those shares. The appellant did not receive permission to appeal the judge's order. Zavarco then forfeited the shares and, as it was entitled to do under the Articles of Association, sought payment of the nominal value of the shares from the appellant as a debt. It did so by commencing proceedings for the payment of 36 million euros. The appellant defended the claim, arguing that the claim was an abuse of process and invoking the doctrine of merger. We are no longer concerned with the abuse of process defence, which failed in the courts below and has not now been appealed. The doctrine of merger provides that a judgment which determines a cause of action extinguishes that cause of action. In other words, the right to obtain another remedy arising out of the given factual circumstances is extinguished because the right to the remedy is replaced by the judgment which has been obtained. The doctrine's purpose is to support the good administration of justice by promoting finality of litigation. It prevents duplicative actions, both in the public interest and in the interest of the parties. The sole issue in this appeal is whether the doctrine of merger applies to declaratory judgments. Before the Chief Master, the appellant sought to set aside Zavarco's claim on the ground that the declaratory judgment, which determined Zavarco's cause of action, so the declaratory judgment had determined Zavarco's cause of action, and Zavarco's claim for payment involved a cause of action which was identical to that which had been extinguished by the operation of the doctrine of merger. The Chief Master upheld the appellant's argument and set aside the claim. Zavarco then appealed to the High Court, and Mr. Justice Burse allowed his appeal, holding that while some declarations might be caught by the doctrine of merger, a declaration which declares merely the existence of a right which the claimant already had before judgment could not extinguish that pre-existing right. As he said, it does the opposite. The appellant then appealed to the Court of Appeal, which dismissed the appeal, holding that the doctrine of merger had no application to declaratory judgments. The appellant now appeals to this court with its permission. In a unanimous judgment which I deliver, this court dismisses the appeal. In the judgment, the court looks at the early historical development of the doctrine in the 17th century and the two following centuries since the case of Broom and Wootton in 1604. Those cases show that the policy behind the doctrine was to achieve finality in litigation and prevent a defendant being vexed by duplicative claims. The thinking underlying the doctrine was that a judgment created a more certain or higher remedy than, for example, a claim for breach of contract. The claimant, on obtaining judgment, could use the judgment to enforce his or her right rather than renew a claim for breach of contract. Further, the idea was that the judgment was a matter of record, and the doctrine at common law applies only to judgments of courts of record and not judgments of foreign courts. In 1982, the Civil Jurisdiction and Judgments Act introduced a statutory bar which in effect extended the doctrine to apply in relation to judgments of courts elsewhere in the United Kingdom and judgments of foreign courts. Now, it's long been recognised that the doctrine could apply harshly to defeat meritorious claims, and since 1935, statute has provided that a judgment obtained against one person liable in respect of a debt or damage does not bar a claim against another person jointly liable with him in respect of the same debt or damage. But harsh results can still occur where the claimant has several claims arising from the same cause of action and fails to pursue them all in one action, as the case of the Indian Grace in 1993 demonstrates. After reviewing the history of the case law, the judgment explains that the doctrine of merger applies only to judgments involving the payment of money or enforcing a right of property by ordering the return of property, judgments which I call coercive judgments. It applies only to judgments which create such obligations. The court holds that the doctrine should not be extended to declaratory judgments for several reasons. First, the doctrine was fully developed before the courts developed the practice of giving purely declaratory relief. Secondly, there may be justifiable reasons for a claimant to seek a declaration before pursuing a claim for a coercive remedy. For example, in this case, Zavarco may have wished to resolve the dispute whether the shares had been fully paid before they took the step of forfeiting the shares. Thirdly, the doctrine has been criticised for its rigidity and its potential to cause injustice. Extending it further would be incongruous. Fourthly, there is no risk of duplicative legislation by allowing a declaratory judgment to be followed by, for example, a claim for payment, because the declaration itself establishes the claimant's entitlement on the merits. And fifthly, there are currently a range of legal rules and remedies by which the court can promote finality of litigation and avoid duplicative disputes, as well as case management powers which weren't available when the doctrine of merger was developed. There is not now a gap to be filled by expanding the scope of the doctrine of merger. The appeal is therefore dismissed. The court will now adjourn.